Johnson, you have possession of weapon or ammo by a convicted felon. We need to talk about bond. Count 2 is $75,000. It's trafficking in oxycodone between 7 and 14 grams. Count 3 is sell cocaine within 1,000 feet of a school, child care or park, $7,500 bond. Same thing, $7,500 bond for count 4, deliver oxycodone within 1,000 feet of the school, child care or park. Then we have count 5, deliver or distribute MDMA, which is ecstasy, $2,500 bond. Count 6, possession with intent to sell, manufacture, deliver cocaine, $2,500 bond. And then we have count 7, possess with intent to sell, manufacture, deliver MDMA, ecstasy, $2,500 bond. Any objection to probable cause?
No, Your Honor.
Okay, the court does find probable cause. Let's talk about bond on one state.
Good morning, Your Honor. Good afternoon, Your Honor. Katia Palmiato on behalf of the state of Florida. A couple things I want to advise the court. As far as Mr. Johnson's priors, he does qualify as a career criminal. His priors are battery in the jail, aggravated assault, possession of a weapon, robbery, and aggravated battery. Furthermore, Your Honor, Mr. Johnson is currently being prosecuted by myself for first-degree felony murder under case number 15-12386 CF10A, and he was currently out on pretrial release for the homicide. So first I'm going to start with the pending charges in front of this court. On the possession of a weapon or ammunition by a convicted felon, I would ask the court to send $100,000 bond. On
Count 1?
Yes, Your Honor.
Okay.
Count 2, I would ask the court to increase his bond to $100,000. Count 3, I would ask the court to increase that bond to $10,000. Count 4, I would ask the court to increase that bond to $10,000. Counts 5, 6, and 7, I would ask the court to increase those bonds to $5,000. Furthermore, pursuant to 903.047, I'm going to be asking the court at this time to enter an order to revoke Mr. Johnson's pretrial release and to hold him no bond on his pending first-degree murder charge that is pending in front of Judge Bober and career criminal.
12386 CF10A.
Sure, Judge. I can also let you know on the homicide, he's being represented by Mr. O'Donnell. I stepped outside. I let Mr. O'Donnell know.
Private?
He is court appointed because there was a conflict on Mr. Johnson's homicide case. So I let Mr. O'Donnell know that he's been arrested. I also let him know that I was asking this court to revoke his pretrial release. He does not represent Mr. Johnson on the new charges. In fact, he didn't know, as you can imagine, that he was arrested. Judge, it was an agreed-upon order that myself and Mr. O'Donnell entered into, and he was simply our ward. He initially had no bond, and we agreed, based on some things that came up in the homicide, we agreed that he would be our ward.
Judge Bober here.
Judge, my position is that pursuant to the statute specifically says that it doesn't matter if he's released on his own recognizance or on a surety bond. Even if there are no conditions in place and there's not a bond, he cannot commit new crimes. So I don't think it makes a difference whether this court makes that determination or Judge Bober, because he violated this statute and he committed a new law violation. And not just any law violation, Judge. It's not like he was arrested for a battery. He's a career criminal. He's a convicted felon. Not only is he in possession of ammunition, but on top of that, he's trafficking in drugs, selling drugs near a school, a church, or a park, in addition to dealing drugs. So these are they're very serious offenses. Trafficking in oxycodone is a first-degree felony. The rest of the charges are second-degree felonies. He's going to qualify as a career criminal on all of those charges because he's a habitual offender. So based on that alone in this statute, I'm asking the court to revoke his bond. Obviously, Mr. O'Donnell, if he feels it's necessary, he could file a motion, and obviously that motion is going to be heard in front of Judge Bowler.
Judge, the state's not moving for pretrial release, that they're not moving to revoke
Can you
bond.
hold
They're
on a
asking
second?
to
Can you hold on, I'm looking something up.
Sure.
I'm sorry.
Yes, Judge, the state hasn't filed a motion under the rules. They need to do it and have 3 hours notice if that's what they're seeking to do. I'm not sure why she's coming in here or tennis moving for that. Your Honor does have the ability to do it sua sponte, but I'm not sure why the state's coming in here to argue a motion they haven't set down. And I think it'd be more appropriate for, based on the circumstances, Judge Lynch to hear it and allow the
I think
state
it was
to
Judge
do it.
Bover.
Yeah, Judge Bover to hear it and give time for his counsel, for which I have a conflict on, there's a conflict, to hear it and be able to make the representative arguments rather than some coming through here where I have no ability to represent him on that. As to these counts, I'm informed that the ammo by a convicted felon was a shotgun shell that he found somewhere. And so I'm asking that you give him a reasonable bond and not set it so high that he won't be able to bond out. I'm sure you're probably going to give him some kind of ankle monitor. If that's the case, I'm not sure how any monetary bond or any kind of stacks of $1,000 bills to a bail bondsman is going to affect the safety of the community. So I'm saying set it at 1,000 and leave all the rest the same.
And looking at 903.047, it says upon motion by the defendant to bail is set, or later motion properly known as pursuant to law, the court may modify the condition required by 1B. She's talking about near contact order with the victim. So I don't see how, show me 903.047.
It's 1A, Your Honor. And just so we're clear, it's a different statute to revoke bond. I'm not asking to revoke bond because there is no bond. So that's why I'm moving under 903.047, which is conditions of pretrial release. And under 1A, it specifically says that whether the defendant is released on surety bond or recognizance bond, or in some other form, the defendant must refrain from criminal activity of any kind.
And again, this is an origin of motion without this attorney being present. The state can file this and give them 3 hours notice like they're supposed to, but they haven't. They came in here and ambushed us, and I can't speak for him on that because there's a conflict of interest.
Judge, as the court knows, there's no requirement that I have to file a motion. For a motion to revoke bond, I have to give him notice in 3 hours, and obviously, Judge, you've been doing this a while, you know that the court, sua sponte, can also revoke his pretrial release or his bond. I don't have to file a motion, I don't have to give him notice, not to mention, I called his lawyer does not represent him on this case. His lawyer is well aware that I was moving to revoke his pretrial release because there's probable cause that this court has found that he committed 7 new offenses, all felonies, some of them first-degree felonies, while he's out on a first-degree murder charge. That is correct, Judge. We agreed on. There's no question about that. But that doesn't mean that he gets to go out in the community and commit new crimes.
Judge, I just have one last thing to say and address. Procedurally, the state just comes in here and wants to argue a motion without having filed anything that's going to deprive someone of their liberty. It's true, yes, you, Your Honor, can sua sponte revoke his bond. I'm saying that it'd be better for the division judge to be able to make that determination when he has counsel in front of him for a very serious charge and not allow any of the state's arguments to be taken into consideration since it's either sua sponte by you, your decision, or they file a motion, not both. They don't get to come in here and ambush people and not file a motion.
Judge, I understand the state's representation that what it seems to me they're just asking the court to sua sponte do this. I know the state's representing that they spoke to this gentleman's attorney on the case. I think the state just mentioned before that he doesn't represent on this case, and I would disagree that he doesn't represent on the case on the magistrate docket, but he certainly it represents on the case that they're asking Your Honor to hold him no bond. I think that at least he should have his counsel here or by phone to consider that portion of it.
Or the state can move like we're supposed to under the rules of procedure and set it in divisions.
Okay, I
And
heard
that's everyone
that.
present.
I heard you. Don't worry, I
Okay.
heard you. All right, would you like to say anything else with regard to the amount of bonds in the instant case we're here on?
Just that it was a shotgun shell that he found, and because he's a convicted felon, we're trying to throw him away and raise the bond so high. He's not in danger, as far as these cases have, he's not found guilty of the murder case that he's facing, so he's not violent as far as these counts. I'm just asking for $1,000 to put in place and all the rest of the things.
Right, this is what the court's gonna do. The court is gonna set bond on count 1 at $50,000. The court's gonna leave bond at 75. On count 2, 3, 4, the court's gonna leave at 7,500. 5 and 6 and 7, the court's gonna leave at 2,500. The court is gonna do a GPS level 1 without, prejudice, obviously, for him to go before his division judge. The court is going to take no action and defer on the state's Ori Tennis motion to, I guess we wouldn't call it to revoke bond, we'd call it, what did you call
To
it?
revoke pretrial release pursuant to 903-047.
903-0471A. The court's going to defer that to the division judge, Judge Bober. Okay? Thank you very much.